us discuss part 4 of the Indian Constitution that deals with directive principles of state policy. We'll talk about what are these DPSPs, what is the relationship of fundamental rights with directive principles of state policy. Is it time for India to enact a uniform civil code in this country? All this and much more in this lecture. But first up, what do we mean by this phrase, directive principles of state policy? If you look at this phrase, you will understand what it means. Those principles which direct the state when the state is enacting policies. That is what we call directive principles of state policy. That means those principles which the state must keep in mind while the state is making policies, while the state is enacting laws. That is what we call directive principles of state policy. But what is the definition of this term state? When we talked about fundamental rights, therein we talked about under Article 12, the definition of state. I told you that throughout this lecture on fundamental rights, we will encounter a term called state. The state shall not do this, the state shall not do that. What is the definition of the state? That definition we provided under Article 12 of the Indian Constitution. The definition of state in Article 12 is the same definition of the state in directive principles of state policy. That means when we talk about those principles that the state must keep in mind while formulating policies, while enacting laws, that is what we call directive principles of state policy. But what is the state? The definition of the state in Part 3 of the Indian Constitution is the same as that of Part 4 of the Indian Constitution. That means the government of India, the Parliament of India, the government of a state, the legislature of a state, the local bodies or those companies which are owned by the government. That is what we call state. And this state shall have to keep certain principles in mind when the state is making policies, when the state is enacting laws. And that is what we call directive principles of state policy. This Part 4 of the Indian Constitution, it covers Articles 36 to 51. Article 36 talks about the definition of the state, and the definition of the state in Part 4 is same as that of Part 3 of the Indian Constitution. But then Articles 37 to 51, what they contain? They contain positive obligation of the state. Now, what is this positive obligation of the state? If we look at fundamental rights, they are negatively worded. And what is this negatively worded? The state shall not deny equality. The state shall not discriminate. The state shall not deprive an individual of his right to life and personal liberty. The state shall not do this. The state shall not do that. That means what the state cannot do. These are negative obligations on the state. That means the state does not have the right to deprive an individual of his right to life and personal liberty. The state does not have the right to discriminate people on the grounds of religion, race, caste, sex, place of birth. That means fundamental rights chapter is asking the state to please stay away and don't interfere with the rights and liberties of the people of this country. But when we talk about directive principles of state policy, we call them, these are positive obligations of the state. Here the Constitution is asking the state, please interfere. Please interfere so that we can organize village panchayats in every single village in this country and empower these panchayats in such a manner that they become agents of rural, local self-government. The Constitution is asking the state, please interfere so that the gulf between rich and the poor is minimized. Please interfere so that maternity relief is provided to the women in this country. Please interfere so that executive and judiciary are separated from each other. Please interfere so that institutions of national importance, our monuments, are kept safe. That means directive principles, they are positive obligations of the state. Here, the Constitution is asking the state, please interfere. In fundamental rights, the Constitution is asking the state to stay away. But here in directive principles, the Constitution is asking the state, please interfere so that we can implement the policies contained under Article 37 to 51 of the Indian Constitution. That means these articles under Part 4 of the Indian Constitution, they contain positive obligation on part of the state. And these provisions we have borrowed from the Constitution of Ireland. And Irish Constitution in turn borrowed these provisions from the Spanish Constitution. Can be an important statement for your prelims examination. But now, let's dig deeper into this chapter. Directive principles have emerged along with the constitutional form of the government. In monarchy or in dictatorial regime, there is no constitution, and as such, there cannot be a directive principle of a state policy. Let's say, for example, when Pervez Musharraf, he in a military coup, removed Nawaz Sharif as the Prime Minister of Pakistan, he suspended the constitution. That means in a dictatorial regime, either the constitution is absent or the constitution is suspended. But if there is a constitution, along with the constitutional form of government, there has emerged directive principles of state policy. So that these directive principles of the state policy will direct the state when the state is making laws, when the state is making policies, when the state is enacting various measures for the upliftment of the people of a particular country. That means directive principles, they have emerged along with the constitutional form of government. But at the same time, the primary objective of directive principles of state policy is to establish a welfare state and not a laissez-faire state. What do we mean by a laissez-faire state? In a laissez-faire state, so far as economic system is concerned, the state does not interfere. That means what to produce, how much to produce, at what cost to produce, the state will not interfere. That means in economic matters, the state is not interfering at all. Do we have examples of a laissez-faire state in today's world? Some commentators say that Singapore is an example of a laissez-faire state. Hong Kong is an example of a laissez-faire state. Denmark, some commentators say, is an example of a laissez-faire state. But the objective of directive principles of state policy is not to establish a laissez-faire state. The objective is to establish a welfare state where the state will interfere so far as economic matters are concerned. Because what is the objective of directive principles of state policy? To promote social and economic democracy. What is the objective of fundamental rights? To promote political democracy in India. What is the objective of directive principles of state policy? To promote social and economic democracy in this country. That means let's recap a bit. What is directive principle of state policy? Those principles that the state must keep in mind when the state is making laws, when the state is making policies. That is what we call directive principles of state policy. And these principles, the primary objective is to establish a welfare state. A welfare state where the society exists for everybody, where the government exists for everybody, whether it is rich or poor, the government exists for everybody. And the objective of these directive principles is not to establish a laissez-faire state where the state will not interfere in economic matters, but to establish a welfare state, a state which exists for every single individual. But when we talk about directive principles of state policy, there are two important characteristics that you have to keep in mind. And that is what Article 37 of the Indian Constitution talks about. Two important characteristics related to directive principles. Number one, they are not enforceable in a court of law. That means, let's say, for example, your right to equality has been violated by the state. Your freedom of speech and expression has been violated by the state. Your right to life has been violated by the state. Your religious rights have been violated by the state. What is the alternative available to you? What is the option available to you? You can drag the state to the court of law. You can file a petition in the Supreme Court of this country. That means whenever your fundamental rights are violated, you can approach the judiciary in this country, and Supreme Court is the protector of your fundamental rights. But these directive principles are not enforceable in a court of law. That means even if the state is not implementing Uniform Civil Code, you cannot approach the judiciary. You cannot file a case in the judiciary asking the judiciary that please direct the parliament to enact a Uniform Civil Code in this country. That means if these directive principles are not implemented, you cannot drag the state to the court. You cannot file a case before the Supreme Court against the state. these directive principles are not enforceable in a court of law. But why? I'll tell you slightly later. Slightly later, I'll tell you why these directive principles of state policy, they are non-justiciable in character. They cannot be enforceable in a court of law. But nevertheless, the same Article 37, which talks about that these directive principles are not enforceable in a court of law, the same Article 37 talks about that these directive principles are fundamental in the governance of the country. That means fundamental for the governance of the country are these directive principles of state policy. The Constitution says it shall be the duty of the state to implement these directive principles of state policy. That means although they are not enforceable in a court of law, but nevertheless they are fundamental for the governance of the country. It shall be the duty of the state to implement these directive principles of state policy. Why these directive principles are non-justiciable in character, despite the fact that they are fundamental for the governance of the country, that I'm going to tell you slightly later. But when we look at these directive principles from Article 38 to 51, because Article 36 tells us the definition of state, Article 37 tells us that these are not enforceable in a court of law, but nevertheless they are fundamental for the governance of a country. But if we look at other directive principles from Article 38 to 51, we can categorize these directive principles into socialist principles, into Gandhian principles, into liberal intellectual principles. But one important thing, Constitution does not talk about this differentiation. Constitution does not say that these are Gandhian directive principles, these are socialist directive principles, these are liberal intellectual directive principles. No. But for the sake of understanding, constitutional experts have looked at these directive principles and they have categorized these directive principles into socialist, Gandhian and liberal intellectuals. Tomorrow in your prelims examination, there can be a question, there can be an MCQ, that which of the following directive principles are Gandhian in character? Which of the following directive principles are liberal? Which of the following directive principles are liberal intellectual in character? Which of the following directive principles are socialist in character? So does that mean you have to memorize all these directive principles one by one? Yes. But is it possible to memorize all these directive principles one by one? Perhaps not. But perhaps it is not needed. Why? Because I'll give you a formula. I'll give you a trick. Using this trick, even if you have never read a directive principle, even if you have not read what are these directive principles, you will still be in a position to identify whether this directive principle is Gandhian, liberal or socialist. How? If you understand what is socialism, if you understand the ideology of Mahatma Gandhi, if you understand the concept behind liberal intellectualism, then you can safely answer every single question if the question asks you to identify what is the character of these directive principles. How? Let me give you a few examples. Let's say, for example, if there is a directive principle which is talking about minimizing inequality, which is talking about bridging the gulf between rich and the poor, what sort of directive principle is it all about? What sort of directive principle is it? It's a socialist principle, because socialism talks about that inequality should be eradicated. Socialism talks about a society where there is equality of treatment. Socialism talks about a society where there are no classes. Socialism talks about a society where workers in factories are entrusted with management of these factories. That means if there are principles which talks about socialist ideas, principles such as, number one, the state shall ensure that economic system does not result in the concentration of wealth in fewer individuals. What sort of a principle are we talking about? Socialist principle. If a directive principle talks about that workers of the factories must be involved in the management of the factories, it's a socialist principle. Equal work for equal pay, it's a socialist principle. That means if you understand the concept of socialism, even if you have never read these directive principles, you can easily answer that this directive principle deals with socialistic principles. What is the idea of Mahatma Gandhi? Mahatma Gandhi believed that India lives in the villages and we have to empower villages. How can we empower villages? by setting up Panchayati Raj institutions. So if a directive principle talks about that the state shall take steps to organize village panchayats at every single village in this country, then which principle is it? It's a Gandhian directive principle. Mahatma Gandhi was also against consumption of liquor. So if a directive principle talks about that there should be a prohibition on intoxicating drinks, that means this directive principle talks about Gandhian principle. Mahatma Gandhi started a program wherein Mahatma Gandhi said that unless and until the upper caste Hindus, they apologize for how they have mistreated and maltreated the disprivileged sections of our society, the untouchables or Dalits of our society, Hinduism will perish. That is why if a directive principle talks about special provisions for SCs and STs in this country, it is a Gandhian directive principle. If a directive principle talks about prohibition of cow slaughter, then we are talking about a Gandhian directive principle. But if there are directive principles talking about separation of executive from judiciary, it is a liberal intellectual principle. If a directive principle talks about promotion of world peace, it's a liberal intellectual principle. If a directive principle talks about protection of monuments, protection of wildlife, environment, then these are liberal intellectual principles. That means when we look at these directive principles, we can categorize these directive principles into Gandhian principles, socialist principles, liberal intellectual principles. Tomorrow there can be a question in your prelims examination wherein you will have to identify whether these directive principles mentioned, whether they are Gandhian in nature, socialist in nature, or liberal intellectual in nature. Even if you have never read these directive principles, even then you will be in a position to answer because you understand the logic behind these concepts. What is liberalism? What is Gandhian principle? What is socialism? If you understand these three concepts, you will be in a position to answer any question asked in your prelims examination. But then if directive principles are those principles which direct the state when the state is making laws, when the state is enacting policies, there are some directives which are outside Part 4 of the Indian Constitution. That means there are some directives under Part 4 of the Indian Constitution, but there are some directives which are outside of the Part 4 of Indian Constitution. And these are three directives that we shall have to discuss. Number one, Article 335 of the Indian Constitution. Not part of Part 4 of the Indian Constitution, but nevertheless, it's a directive to the state, but outside of Part 4 of Indian Constitution. What is Article 335? Whenever the state is inviting applications for government jobs, when the state is inviting applications for government jobs, the state shall have to keep in mind the claims of SCs and STs in this country, but consistently with the maintenance of efficiency of administration. That means if efficiency of administration is taken care of, then we should also take a look at the claims of SCs and STs because they also would want government jobs. That's the directive to the state. You have to keep in mind the claims of SCs and STs when you are inviting government jobs. That means you have to keep in mind the claims of SCs and STs when the government is inviting applications for government jobs. Another directive, Article 350 capital A. Let's say, for example, we are in Maharashtra. And in Maharashtra, we have Tamils also. If these are Tamils, that means these are linguistic minorities in Maharashtra. There is a directive under Article 350 capital A that the Maharashtra government shall have to ensure that these Tamil linguistic minorities, the children of these Tamil linguistic minorities, they are provided education in their own mother tongue, at least till primary stage of education. That means at least till primary stage of education, if there are linguistic minorities in a particular state, this state shall have to ensure that these linguistic minorities are provided education in their own mother tongue. That's the directive under Article 350 capital A. Then we have Article 351 of the Indian Constitution. And it talks about that it shall be the duty of the union. And union will have to promote the spread of Hindi language so that this Hindi language is developed as a medium of expression for all the elements of the composite culture of India. That means if we look at it this way, the previous government tried to promote Hindi. The foreign minister, she made a speech at the United Nations in Hindi. The budget speeches presented by the finance ministers, it was in English as well as Hindi. All India radio bulletins were mostly promoted in Hindi language. PIB, Press Information Bureau, promoted in Hindi language. So there were many who were complaining that the previous government is unnecessarily promoting Hindi language at the cost of the regional languages. And many people argued that government does not have the mandate to do that. But they were wrong, because there is a directive outside Part 4 of the Indian Constitution, and this directive says that it shall be the duty of the Union to promote Hindi language. So if any government at the center is promoting Hindi language, it is not unconstitutional, because the Constitution entrusts the responsibility with the center, with the Union, that you shall have to promote Hindi so that this language becomes the medium of expression. So there are directives under Part 4 of the Indian Constitution, but there are directives outside the Part 4 of the Indian Constitution as well. For example, Article 335, Article 350 capital A, and Article 351 of the Indian Constitution. But now let's look at this chapter in great detail. Till now we have understood what is a directive principle of state policy. We have borrowed it from Irish Constitution. They in turn borrowed it from the Spanish Constitution. We differentiated these directive principles as Gandhian principles, socialist principles, liberal intellectual principles. There are some directives which are outside of the Part 4 of the Indian Constitution. That means these are directives to the state, but they are not mentioned under the chapter Directive Principles of State Policy. They are outside of this chapter. They are mentioned somewhere else in the Constitution. 335, 350A, 351. But then, when we looked at the characteristic of directive principle, Constitution says, although these directive principles are not enforceable in a court of law, but nevertheless, they are fundamental in the governance of the country. If it is the duty of the state to implement these directive principles of the state policy, and now if the state is trying to implement these directive principles of state policy, what if there is a clash with the fundamental rights? What if the state is trying to implement a directive principle of state policy, but in the process, it is violating fundamental rights? Which is superior? Are fundamental rights superior, or are directive principles superior? What is the relationship between fundamental rights and directive principles of state policy? For that, let me take you back to Article 15 of the Indian Constitution. When Article 15, for that, let me take you back to the state of Madras in the year 1951. The Madras government started a policy where members belonging to SCs and STs, they shall be provided reservation in government educational institutions, in government engineering and medical colleges. Matter went to the court. Champak Dorarajan versus State of Madras, 1951. The Supreme Court was asked that their Supreme Court, Madras government, has violated Article 14 of Indian Constitution, which is right to equality, has violated Article 15 of Indian Constitution, which talks about that there shall be no discrimination on the grounds of caste. So if Madras government has violated fundamental rights, please declare that this reservation policy is unconstitutional. The Supreme Court asked the Madras government, how can you do that? How can you provide reservation to SCs and STs primarily on the basis of their caste, because you are violating Article 14 and Article 15 of the Indian Constitution? Madras government said, but we are trying to implement Article 46 of Indian Constitution. Article 46 is a directive principle. Constitution says under Article 37 that it shall be the duty of the state to implement these directive principles of state policy. Article 46 talks about that the state shall make provisions for the upliftment of SCs and STs and other marginalized communities in this country. We are only trying to implement Article 46 of Indian Constitution. The Supreme Court said, but this is unconstitutional, because Article 46 is a directive principle of state policy. Directive principles of state policies, they are inferior to fundamental rights. That means in our constitutional scheme of things, fundamental rights are superior, directive principles are inferior. If the Madras government is trying to implement a directive principle, but in the process, fundamental rights are getting violated. Since fundamental rights are superior than directive principles of state policy, this Madras government's order of reservation is unconstitutional. That means what Supreme Court said, that directive principles are inferior than fundamental rights. And it was on the basis of this judgment that two pet programs of Pandit Jawaharlal Nehru, Land Reforms and Zamindari Abolition Act, they were both declared as unconstitutional because the state was trying to implement directive principles, but in the process fundamental rights were getting violated. Since fundamental rights are superior than directive principles, both these laws were declared as unconstitutional by the judiciary. Indian National Congress, during the freedom struggle, many people attacked this party saying that this is the party of bourgeois. This is the party of the capitalist class. This is not the party of the workers. This is not the party of the landless agricultural laborers. This is the party of bourgeois, capitalists, corporates, big zamindars and landlords. This might have been true in the initial years of Indian National Congress. But then this Indian National Congress got dominated by left-leaning politicians such as Pandit Jawaharlal Nehru, such as Subhash Chandra Bose. And these leaders, they gave Indian National Congress a left-leaning tilt. And now Congress party decided that we have an objective. Once India is given independence, we will ensure that land reforms are implemented in this country. We will ensure that zamindari is abolished in this country. Why should a zamindar who does not till the land, agricultural laborers till the land? Why is it that this zamindar controls massive acres of land in this country and then ultimately the profits are consumed by this zamindar, this landlord? We will ensure that tiller of the land is the owner of the land. We will ensure that this land is evenly distributed to those who work on this land. That means the objective of Indian National Congress was socialism. The objective of the Indian National Congress was to implement land reforms in this country. The objective of the Indian National Congress became that zamindari will be abolished in this country. The land acquired and controlled by zamindar will be evenly distributed to the landless agricultural laborers. But when Constitution was enacted in 1950, Pandit Nehru lived up to his promise. He got the parliament to enact two beautiful laws, Land Reforms Act and Zamindari Abolition Act. And his principal objective was to implement two directive principles, Article 39B and Article 39C. What these two directive principles talk about, please look at the text carefully. 39B says, ownership and control of material resources are so distributed so that they lead to a common good. That means if you look at the material resources, they should be evenly distributed amongst the different sections of our population. What is this material resource? Water is a resource. Land is a resource. Spectrum is a resource. Since land is a resource, it is a material resource, this land should be evenly distributed. This land should be distributed in such a manner that it leads to a larger public good. And for that, Land Reforms Act was passed by the Indian Parliament. Directive Principle 39C, our economic system should be implemented in such a manner, should be operated in such a manner that it does not lead to concentration of wealth in fewer individuals. That means our economic system should be such that wealth should be distributed. Our economic system should be such that rich are not becoming richer and poor remaining poorer. We should ensure that our economic system is such that it prevents concentration of wealth in fewer hands. Since the wealth was concentrated in the hands of the zamindars, that is why zamindari system was to be abolished. And Pandit Nehru got the parliament to enact Zamindari Abolition Act. But Supreme Court said, Article 39B and 39C, these are directive principles of state policy. Directive principles are inferior than fundamental rights. If you are implementing Land Reforms Act, if you are implementing Zamindari Abolition Act, you are violating Article 14, 19 and 31 of the Indian Constitution, which is a fundamental right. And since directive principles are inferior than fundamental rights, that is why both these laws are unconstitutional. Article 14 talks about a right to equality. Article 14 talks about equal protection of the laws. So how are you discriminating zamindars against the landless workers, against the landless agriculturists? Article 19, Clause 1, Clause F talks about that every single individual in this country, every single citizen in this country shall have the fundamental right to acquire property, to dispose of property as well. But you are depriving these zamindars of disposing of their property because you are snatching property from them. You are violating Article 19. Article 31 talked about acquisition of the property by the state. That means the state will have the power to acquire property. And this right is not given by the Constitution explicitly. This is where we encounter a doctrine called doctrine of eminent domain. What is this doctrine of eminent domain? Doctrine of eminent domain says that if this is a private property, this private property can be acquired by the state. State has the right to acquire this property. If this private property is to be put to use by the state for a larger public good, that means if I own a private property, under the doctrine of eminent domain, the state can acquire this property for a larger public good. That means the state wants to use this land for the construction of a hospital, for laying down railway lines, for laying down road, for constructing a school or a university. That means if the intention of the state is to acquire this property for the larger public good, under doctrine of eminent domain, this is the power of the state. But Article 31 talks about even if this private property is to be acquired by the state, compensation should be provided. That means compensation should be provided to the owner of this private property. But when zamindari was abolished, not much compensation was provided to the zamindars. These zamindars approached the judiciary that the state is acquiring our property, but at the same time compensation is very poor, or in most cases no compensation is provided. In that case, you are violating Article 31 of the Indian Constitution. And that is why Zamindari Abolition Act, Land Reforms Act were declared unconstitutional by the judiciary. That means in the initial years of the Republic, the position of the Supreme Court was that directive principles are inferior than fundamental rights. Yes, directive principles, it shall be the duty of the state to implement these directive principles. But if you are implementing these directive principles and in the process you are violating fundamental rights, then it is the fundamental rights which will be given primacy, because fundamental rights are superior than directive principles of state policy. And by this logic, in Champak Dorerajan versus State of Madras, the Supreme Court said land reforms and Zamindari Abolition Act, they are unconstitutional because you are implementing directive principles at the cost of fundamental rights. That is something which cannot be accepted. This judgment was a setback to Pandit Nehru. He wanted to implement land reforms in this country. He wanted to ensure that Zamindari is abolished in this country. Then Constitution was amended. When Constitution was amended, the first Constitutional Amendment Act was passed in the year 1951. Article 31A was added. Article 31B was added. What is Article 31A? Article 31A says, if the state wants to acquire an estate, a private property, and the intention is that this private property can be put to use for a larger public good, then even if this law violates Article 14, 19 and 31, you cannot declare that this law is unconstitutional. That means when in Champak Dorerajan case, Supreme Court said you are implementing directive principle, but in the process you are violating fundamental rights, we will not allow you to do so because directive principles are inferior than fundamental rights. Then what happened? Constitution was amended. The The Constitution now says under Article 31A that if the state acquires an estate, even if the state acquires an estate and in the process of acquiring the state, Articles 14, 19 and 31 are violated, this law should not be declared unconstitutional on this ground. That means this Article 31A authorized the state to acquire a private property even if Article 14, 19, 31 is violated. Article 31A also provided power to the state that what you can do, you can take over the management of any property in public interest. That means now the state has the power to take over the management of any company as well, any private property as well, if it is for the larger public interest. This is Article 31 capital A. And Article 31 capital B added another schedule to the Indian Constitution called 9th Schedule of Indian Constitution. What is the significance of 9th Schedule of Indian Constitution? Any act, any law placed in 9th Schedule of Indian Constitution is immune from judicial review. That means judiciary cannot question the validity of a law which is placed in 9th Schedule. But the beauty of 9th Schedule is that it is retrospective in nature as well. What do we mean by retrospective nature? Supreme Court in 1951 said, Land Reforms Act unconstitutional. Zamindari Abolition Act unconstitutional. That means they won't enter into force because they are violating the Constitution. When 9th Schedule was added to the Indian Constitution, these two laws were placed in 9th Schedule. That means even after these laws were declared as unconstitutional by the judiciary, these laws were added to the 9th Schedule of Indian Constitution. Now there is no judicial review. That means judiciary cannot question the validity of these laws because these laws have been placed under 9th Schedule of the Indian Constitution. But despite these two amendments, despite adding 31 capital A, despite adding 9th Schedule to Indian Constitution, despite these amendments, the position of the court is still clear. Directive principles are inferior than fundamental rights. What is the current status of this 9th Schedule of Indian Constitution? That we will discuss when we will discuss schedules of Indian Constitution. So as of now, what you need to understand is that there is a 9th Schedule. Any law placed in 9th Schedule is immune from judicial review. And this is the status in 1951. But over a period of time, the judiciary also realized the significance and importance of directive principles of state policy. The year was 1958. The Supreme Court was hearing a presidential reference called Kerala Education Bill. What is this RE? RE is a presidential reference. We will discuss this in detail in judiciary, but very briefly here. Under Article 143 of Indian Constitution, President's advisor is the Supreme Court, or Supreme Court is the advisor of the President of India. President can refer any matter to the Supreme Court, asking the views of the Supreme Court on that matter. Here in this case, this Kerala Education Bill was referred by the then President of India to the Supreme Court, asking the views of the Supreme Court on this matter. Because Kerala Education Bill, it tried to standardize syllabi in Kerala schools. It tried to standardize the pay scales of the teachers in Kerala schools. And these schools were majorly controlled by the private players. And if the state is interfering in the syllabi and pay scale of the teachers in these private schools, that means you are violating fundamental rights of these private players. You are violating their Article 14, you are violating their Article 19, you are violating their Article 31, which is the right to property. In this case, the President thought it fit that we should refer this matter to the Supreme Court because in 1951, Supreme Court said directive principles are inferior than fundamental rights. Here in this case, the Supreme Court propounded a doctrine called Doctrine of Harmonization. What is this doctrine of harmonization? Supreme Court said directive principles and fundamental rights, they are to be harmoniously interpreted. They are to be harmoniously constructed. Supreme Court said there is no inherent conflict between directive principles and fundamental rights. Both should be implemented. If fundamental rights are there for the promotion of political democracy, democracy in this country, directive principles are there for the promotion of social and economic democracy in this country. So directive principles and fundamental rights are to be harmoniously constructed. You should implement one by one all these directive principles because there is no conflict between directive principles and fundamental rights. But then Supreme Court dropped a bombshell. Supreme Court said even if there is no inherent conflict between directive principles and fundamental rights, but if you are trying to give effect to directive principles of state policy and in the process fundamental rights are violated, we will ensure that fundamental rights are safeguarded, some fundamental rights are protected. We will declare that this law is unconstitutional if you are violating fundamental rights. That means despite this doctrine of harmonization, Supreme Court is clear. Directive principles are inferior, fundamental rights are superior. And it was on the basis of this judgment that two laws, Bank Nationalization Act, Privy Purses Abolition Act, they were declared unconstitutional by the judiciary. Let's look at what is this Bank Nationalization Act. Bank nationalization primarily means that private banks will be nationalized. The control of these private banks will be given to the government. That means now government will control these private banks. That's what we call bank nationalization. Indira Gandhi started the scheme of bank nationalization because she believed that these private banks are primarily catering to the capitalist class, primarily catering to the upper class of the society. They are neglecting the farmers, they are neglecting the downtrodden, they are neglecting the poor sections of the society. The poor people in this country do not have access to credit. Poor people in this country do not have access to loans in this country. So since these banks are privately owned, privately controlled, they are catering only to the bourgeois, they are catering only to the capitalist class, they are catering only to the upper class. One solution is let's nationalize these banks. So 14 banks were nationalized by Indira Gandhi government. Matter went to the court. The Supreme Court asked Indira Gandhi government, how can you do that? How can you deprive a private individual of his property? The Supreme Court was told by Indira Gandhi government that we have Article 31 of Indian Constitution. Article 31 talks about that the state can acquire the property, acquire the private property of an individual if larger public interest is involved. So in the larger public interest, we are nationalizing these banks. Supreme Court said, yes, that is your right under doctrine of eminent domain. Under doctrine of eminent domain, the state has the right to acquire the private property of an individual if it is for larger public interest. So we understand that there is a larger public interest involved herein. That is why you are nationalizing these private banks. But where is the compensation? Compensation you have to provide. And this compensation should be fair. This compensation should be just. Indira Gandhi government told the Supreme Court that we are providing compensation to these private banks in the form of bonds. The Supreme Court said, yes, you are providing bonds to the owners of these banks, but these bonds will mature after 10 years. What are these private owners of these banks going to do for these 10 years? That means we are not questioning the right of a state to acquire the private property if it is for larger public interest. But compensation you have to provide. Now you are saying we are providing them compensation in the form of bonds, but these bonds will mature after 10 years. Constitution is clear. You have to provide compensation, and this compensation should be fair. This compensation should be just. Then you are saying we are providing compensation to them in the form of bonds, but these bonds will mature after 10 years. This is neither fair compensation nor is it a just compensation. That is why Bank Nationalization Act is unconstitutional, because you are trying to implement directive principle, but in the process you are violating fundamental rights. Since fundamental rights are superior, directive principles are inferior, Bank Nationalization Act is unconstitutional. What about Privy Purse? There were more than 562 princely states in India. These princely states were provided with options. Either you can join India, or you can join Pakistan, or you can stay independent. It was because of Sardar Vallabhbhai Patel, who is known as the man of unity. What he did, he tried to integrate as many princely states into Union of India as possible. But there was a bargain. What was the bargain? Sardar Patel negotiated with these princes, told them that you have this property, you keep this property. You have the resources, keep these resources. All these bungalows, all these mahals, all these havelis, you keep them. Keep the diamonds, keep the money, keep the vintage cars with you. On top of that, we are going to provide you with a privy purse. On top of that, we are going to provide you annual sum of money, which will be equal to 8.5% of your annual revenue. And this privy purse varied as well. For example, the Nizam of Hyderabad was a rich, prosperous, princely state. The Nizam of Hyderabad was paid 73 lakhs every year as a privy purse. But the ruler of Kakodia, a small princely state, was provided 172 rupees a year. That means when these princely states were sought to be integrated into the Union of India, Sardar Vallabhbhai Patel negotiated with these princes, communicated to these princes that all your property will remain with you, all your diamonds will remain with you, all your vintage cars will remain with you. On top of that, we are going to provide you an assured sum every single year. An annual privy purse will be provided to you. But all you have to do, give up on your sovereignty. Merge with the Union of India. We are going to provide you annual privy purse according to the size of your estate, according to the size or the revenue of your princely state. But Indira Gandhi decided that we are going to abolish this privy purse. So the solemn promise, solemn constitutional promise that was given by Sardar Patel to these princes, it was rendered null and void by Indira Gandhi when she decided to abolish this privy purse. Madhav Raj Scindia, who was the beneficiary of this privy purse, he filed a petition in the Supreme Court of this country, and the Supreme Court said this Privy Purses Abolition Act is unconstitutional because you are trying to give effect to directive principle, but in the process fundamental rights are violated. That is why both these acts are unconstitutional. But Indira Gandhi was someone who could not take these judgments lightly. What she did, she got the parliament together, enacted 25th Constitutional Amendment Act in 1971. And this 25th Constitutional Amendment Act introduced another article, Article 31C, to the Indian Constitution. What Article 31C talked about? Article 31C said, if the state wants to enact a law, and through this law, the state wants to implement two directive principles, 39B and 39C. And we have discussed what these two directive principles are. So 31C said, if the state wants to implement a law, if the parliament wants to enact a law, and through this law, the parliament wants to implement two directive principles, 39B and 39C. And in the process, three fundamental rights are violated. Which are these fundamental rights? 14, 19 and 31. That means if the parliament frames a law, and through this law, parliament wants to give effect and implement two directive principles, 39B and 39C, and in the process, three fundamental rights are getting violated, then on this basis, the law should not be declared as unconstitutional. The law should be declared as constitutional, because what Indira Gandhi is trying to do, she is trying to provide primacy to two directive principles over three fundamental rights. That means two directive principles are now superior than three fundamental rights. Article 31C further said that when this law, which is trying to give effect to two directive principles, which is trying to give primacy to two directive principles over three fundamental rights, this law should not be questioned in any court of law. That means there should be no judicial review when such a law is implemented by the parliament, when such a law is passed by the parliament. Matter went to the court. Keshavananda Bharti versus State of Kerala, 1973. This 25th Amendment was challenged in the Supreme Court. Supreme Court said the first part of this 31C, wherein Parliament has said that if we are passing a law, and through this law, if we are trying to implement two directive principles, and in the process of implementing two directive principles, three fundamental rights are getting violated, this law is constitutional. That means Supreme Court in Keshavananda Bharati verdict said that two directive principles, 39B and 39C, they are superior than three fundamental rights, 14, 19 and 31. But Supreme Court said, the second part of this 31C, when you say there should be no judicial review when such a law is being passed by the Parliament, this is something that we cannot agree with. Why? Because judicial review is part of the basic structure of Indian Constitution. Any law passed by the Parliament, any policy issued by the government can be subject to judicial review. Judiciary will have the power to question the validity of any law passed by the Parliament. And this is the power that no amendment of the Indian Constitution can snatch, because judicial review is part of the basic structure of Indian Constitution. That means what happened? We are now in 1973 and we have traveled a lot since 1951. In 1951, Supreme Court said directive principles of state policy are inferior, fundamental rights are superior. On the basis of this judgment, Land Reforms Act, Zamindari Abolition Act were declared unconstitutional. But then there was a constitutional amendment. Schedule 9 was added to the Indian Constitution. Land Reforms Act, Zamindari Abolition Act, they were added to the Schedule 9. And judiciary cannot question the validity of those laws which are placed under 9th Schedule. Then we entered into 1958. 1958, the Supreme Court is propounding a doctrine called Doctrine of Harmonization. But despite Doctrine of Harmonization, Supreme Court made it abundantly clear that directive principles are inferior, fundamental rights are superior. On the basis of this judgment, what happened? Privy Purses Abolition Act, unconstitutional. Bank Nationalization Act, unconstitutional. Supreme Court said, yes, the state has the right to acquire private property, but at the same time you have to provide compensation. And this compensation should be fair, this compensation should be just, this compensation should be reasonable. And when Bank Nationalization Act, Privy Purses Abolition Act, they were declared unconstitutional by the judiciary on the grounds that the state is trying to implement Article 39B and 39C. And in the process, it is violating Article 14, 19 and 31. Since you are trying to implement directive principles, but since directive principles are inferior than fundamental rights will prevail, directive principles will not prevail. That is why these two acts, Bank Nationalization and Privy Purses Abolition Act, they are unconstitutional. But when 25th Amendment was passed, 31C was added. 31C made it absolutely clear that we have two directive principles which are now superior than three fundamental rights which are inferior, 14, 19 and 31. Then emergency was imposed in this country in the year 1975. And during the emergency period, in the year 1976, another amendment was made. And that is 42nd Constitutional Amendment Act, 1976. In this constitutional amendment, Article 31C was again amended. Now Article 31C reads, if the Parliament wants to frame a law, and through this law, Parliament wants to give effect to one or more directive principles, and in the process, this law violates Article 14, 19 and 31, then merely on this ground, the law should not be declared as unconstitutional. That means because of 25th Constitutional Amendment Act in the year 1971, Parliament gave primacy to two directive principles over three fundamental rights. Now in 1976, because of a constitutional amendment, Parliament is trying to give primacy to all directive principles of state policy over three fundamental rights. Matter again went to the court. The last judgment in this case, Minerva Mills, in the year 1980. In this case, Supreme Court said This 42nd Amendment, so far as Article 31 capital C is concerned, is unconstitutional. If you're trying to give primacy to all directive principles of state policy over three fundamental rights in this country, then what happens? You are disturbing the fine balance between directive principles and fundamental rights, which is against the basic structure of Indian Constitution. That means in 1976, the Parliament tried to give primacy to all directive principles over three fundamental rights, 14, 19 and 31. Matter went to the court. In 1980, in Minerva Mills case, the Supreme Court said this is unconstitutional. Why? Because there is a fine balance between directive principles and fundamental rights. If you are disturbing the relationship between directive principles and fundamental rights, you cannot do that because it is against the basic structure of Indian Constitution. Because one of the basic structures of Indian Constitution is the relationship, is the fine balance between directive principles and fundamental rights. If you're trying to give primacy to all directive principles over three fundamental rights, you are disturbing this balance. This is something that we will not allow. So now what is the current situation? So now if we have to recap, 1951, Supreme Court is saying directive principles are inferior, fundamental rights are superior. 1958, Supreme Court is saying doctrine of harmonization. Directive principles are for the promotion of social and economic democracy. Fundamental rights are for the promotion of political democracy. There is no inherent conflict between directive principles and fundamental rights. Implement directive principles, implement fundamental rights. They are to be harmoniously constructed. But if you are violating fundamental rights because you are giving effect to directive principles of state policy, this we are not going to tolerate, because directive principles are inferior, fundamental rights are superior. 1971, two directive principles are given superiority, 39B and 39C, over three fundamental rights, 14, 19 and 31. Supreme Court said in 1973, this is constitutional. That means now two directive principles are superior than three fundamental rights. 1976, all directive principles are given primacy over 14, 19 and 31. Supreme Court said in 1980, this is unconstitutional because the relationship between directive principles and fundamental rights, that is part of the basic structure of Indian Constitution, and no amendment of the Constitution can snatch basic structure of Indian Constitution. So if you look at the current situation, now two directive principles, 39B and 39C, they are superior than two fundamental rights, 14 and 19. Why? Because Article 31 has been deleted now. Why Article 31 was deleted? The Parliament passed 44th Constitutional Amendment Act in the year 1978. Article 19, Clause 1, Clause F, which is the right to acquire and dispose of one's property. And Article 31, which is that the state can acquire the private property, but compensation should be provided. Both these fundamental rights were deleted, and right to property then became a constitutional right under Article 300 capital A. That means right to property, which was a fundamental right till 1978. In 1978, it was deleted as a fundamental right, but it was still retained in the Constitution. But retained not in the chapter of fundamental rights, but retained somewhere else. Where? In Article 300 capital A. That means now right to property is only a constitutional right. It is not a fundamental right. But why was Article 31 deleted or Article 19 Clause 1 Clause F deleted? When the concerned minister presented this bill in the Parliament that we should delete right to property as a fundamental right and make it a constitutional right, the concerned minister gave an argument. The concerned minister gave a justification. Why are we deleting right to property as a fundamental right? The concerned minister said that there is some sanctity which is associated with fundamental rights. And what is the sanctity? The sanctity is that fundamental rights should not be eroded, as frequently as possible. That means there is some sanctity available with fundamental rights, and we can ensure the sanctity of fundamental rights by ensuring that they are not repeatedly amended. But so far as the right to property is concerned, it was amended in the year 1951, it was amended in the year 1956, it was amended in the year 1963, amended in the year 1968, 1969, 1971, 1973, 1976, 1978. So if this right to property has been subjected to frequent amendments, the sanctity of this fundamental right has eroded to a drastic level. That is why right to property should be deleted as a fundamental right. Instead, we will retain it in the constitution, but not as a fundamental right, but as a other constitutional right under Article 300 capital A. That means there is a misconception even today that right to property was deleted as a fundamental right because then the state will have the right to acquire property. That's not true, because there existed Article 31 which clearly said that state can acquire property, but you have to provide compensation. Despite right to property being a fundamental right, we have seen Zamindari Abolition Act was implemented. We have seen land reforms were implemented. We have seen privy purses was abolished. We have seen bank nationalization was implemented in this country after the 1971 amendment. But despite right to property being a fundamental right, we still saw under the doctrine of eminent domain, the state has the right to acquire property. But it was deleted as a fundamental right primarily because of the fact that the concerned minister said that there is a level of sanctity attached to fundamental rights. It should not be subjected to frequent amendments. But since right to property was subjected to frequent amendments over a period of time, the sanctity of this fundamental right got lost. And that is why we are deleting it from the chapter of fundamental rights. We are adding it to a different part of the Constitution under Article 300 capital A. That means right to property today is not a fundamental right, but it is a constitutional right. So if we recap a bit, as of now we have understood what is a directive principle of state policy. We have borrowed it from Irish Constitution. We can classify directive principles into Gandhian, socialist and liberal intellectual principles. It shall be the duty of the state to implement these directive principles under Article 37 of Indian Constitution. But at the same time, they are not enforceable in a court of law. But if the state wants to implement directive principles, what if there is a clash with fundamental rights? What will prevail? Fundamental rights or directive principles? The situation and position today is that there are two directive principles, 39B and 39C, which are superior than two fundamental rights, 14 and 19. But then the question that I raised in the beginning, why is it that if directive principles are fundamental for the governance of the country, why is it that they are not enforceable in a court of law? Why is it that directive principles are non-justiciable in character? To answer this question, we have to look at the arguments presented by Dr. B.R. Ambedkar and Pandit Jawaharlal Nehru, the first Prime Minister of independent India. B.R. Ambedkar said that directive principles are not inferior than fundamental rights. But directive principles are not enforceable in a court of law primarily because of the ground, primarily because of the fact that to implement directive principles, we need time and we need resources. How? Let's say, for example, this is 26th January 1950. Constitution has been enacted. Tomorrow it is 27th January 1950. My right to life has been violated. My right to equality has been violated. My right to religious freedom has been violated. What is the option available with me? I can approach the Supreme Court and the Supreme Court will restore my fundamental rights, because fundamental rights are enforceable in a court of law. But what if it is 27th January 1950 and still there is inequality in the society? Still Panchayati Raj institutions are not established. Still there is a gulf between rich and the poor. Still Uniform Civil Code is not implemented. Still maternity relief is not provided to the women. Still the nutritional standard and the standard of life has not improved for the people of this country. I will drag the state to the court and the court will punish the state. But then the state will ask the court that I don't have time, I don't have resources to implement these directive principles of state policy. That means directive principles are not inferior. That is why they are not enforceable in a court of law. But directive principles are not enforceable in a court of law primarily because of the fact that state needs time and state needs resources to implement these directive principles. B.R. Ambedkar said that although these directive principles, they do not have legal sanction, that means they are not enforceable in a court of law, but they have political sanction. And what is this political sanction that I'm talking about? Any government, if it does not implement these directive principles, they will not be voted into power again by the people. That means the people will punish those political parties. That means the people will punish those governments who are not implementing these directive principles. That means all these directive principles have political sanction. That means, let's say, for example, the government is only catering to the rich, not to the poor. The people will throw out this government. What if a government is not in a position to control inflation? And because of this inflation, the inequality rises between the rich and the poor. The nutritional standards of the people, they are not increased. The living standard of the people is reducing day by day because of this rising inflation. If a government is not in a position to control inflation, this government will be thrown out of power by the people. That means all the governments will try and ensure that these directive principles are implemented because they have political sanction. Any government, if it does not implement these directive principles, this government will be thrown out of power by the people. Let's take the example of the 2004 elections. Everybody was talking about that Atal Bihari Vajpayee will win the election again. The campaign of the BJP at that point in time was Bharat Uday, India shining. But critics say that BJP lost that election because of this campaign of India shining. Because India was shining, but only in urban India. In rural India, farmers were committing suicide. In rural India, there was rural distress. In rural India, the crops were failing. So since directive principles were neglected by the then government, that is why they were voted out of power by the people and a new government was brought in. That means perhaps B.R. Ambedkar is right. Directive principles are not enforceable in a court of law. That doesn't mean they are inferior than any other part of the constitution. It only means that the state needs time and resources to implement them. And these directive principles, if they don't have legal sanction, but they have political sanction. If these directive principles are not enforceable in a court of law, these directive principles are enforceable in the court of the public. Every 5 years, the people will check whether directive principles are implemented or not, and they will vote in or vote out a government. Pandit Nehru made an even more important statement. Pandit Nehru said that these directive principles are like a lighthouse, constantly reminding the government of its responsibility. That means government has a duty. State has a duty to implement these directive principles. When the state or the government will look at this list of directive principles, this list of directive principles is acting as a lighthouse, constantly reminding the government of its responsibility. That means if the objective of directive principle is to implement social and economic democracy in this country, that is why the government will keep a tab of all these directive principles and will check whether one by one these directive principles have been implemented or not. It's like a lighthouse, constantly reminding the government of its role and responsibility. The significance of directive principles of state policy can be gauged from the statement given by Justice Kania, the first Chief Justice of independent India. Justice Kania said, if we look at these directive principles, that doesn't mean directive principles are there in the constitution because majority in the constituent assembly agree to that. No. Directive principles of state policy are mentioned in the constitution because majority of the people of this country wanted it. And majority of the people of this country, through their representatives in the constituent assembly, they got directive principles chapter added to the constitution. B.R. Ambedkar said that directive principles of state policy is like a blank check. This directive principles of state policy is like a check which is encashed by the government at its discretion. Whenever the government has the time and resources, this directive principles of state policy will be implemented by the government. And if we look at these directive principles, one by one, almost all these directive principles have been implemented. For example, Article 40 talked about organization of village panchayats. We have a three-tier panchayati raj system in this country. When we will discuss local government, we will explain what these panchayats and municipalities are all about. But we have implemented them. Article 41 talks about right to work, right to education and public assistance in certain cases. And we have implemented them. Right to work, we have Manrega, Mahatma Gandhi National Rural Employment Guarantee Act, which provides employment opportunities to every single individual in rural India who belongs to below poverty line category. 100 days of paid employment to these individuals. If the state is not in a position to provide them employment for 100 days, unemployment benefit will be provided to them. A right to education is now a fundamental right under Article 21 capital A of the Indian Constitution. A right to public assistance in certain cases. This is how we can talk about a right to free legal aid. If you're a poor, you don't have means to pay a lawyer, then the judiciary under the free legal aid will provide you legal assistance. That means even Article 41 has been implemented. Article 42 talks about provision for just and humane conditions of work and for maternity relief. For this we have maternity benefit law. Every single woman for up to 2 pregnancies, she will be provided paid maternity leave for 26 weeks. And she can avail this 26 weeks of paid maternity leave for 2 children. That means even Article 42 has been implemented. Article 46, which talked about special provisions for the upliftment of SCs and STs. That is something that we have implemented. Article 49, which talks about protection of monuments and places and objects of national importance. We have laws which deal with them. Article 50 talks about separation of judiciary from the executive. And in the year 1973, when Criminal Procedure Code was enacted, separation of executive and judiciary was carried out. Article 51, which talks about promotion of international peace and security. Even this has been the policy of the successive governments, that we want to solve all problems through peace, through negotiation, through dialogue. War is not the option available with the Indian state. So one by one, majority of these directive principles have been implemented. But there are still a few directive principles which have not been implemented. For example, Uniform Civil Code. And we will discuss now Uniform Civil Code in great detail. What is a Uniform Civil Code? Let's say, for example, we have criminal laws and we have civil laws. Criminal laws are common for every single individual. That means regardless of your religion, there is no discrimination. Anybody who commits murder will be booked under Section 302 of Indian Penal Code, regardless of your religion. If somebody commits rape, regardless of his religion, he will be booked under Section 376 of Indian Penal Code. That means so far as criminal laws are concerned, there is no discrimination on the grounds of religion. Whether Hindu, Muslim, Christian, Jain, Buddhist, Parsi commits any crime, all of them will be booked under common laws. So far as civil laws are concerned, majority of these civil laws are also common. That means there is no discrimination on the grounds of religion. For example, disputes related to property. Regardless of your religion, you will come under same law. Similarly, if somebody violates a contract, regardless of your religion, you will come under one common law. Most of the civil laws common for every single individual, regardless of your religion. But there is a section of civil laws called personal laws. This is where there is discrimination. This is where different religions are governed differently. Personal laws related to marriage, related to divorce, related to inheritance, related to adoption. This is where different sections of the people are governed differently. That means Muslims, So far as their marriage, divorce, inheritance, adoption is concerned, they are governed under Muslim Personal Law of the year 1937. Hindus, which include Sikhs, Jains, Buddhists, they are governed under a different law. Christians are governed under a different law. Parsis are governed under a different law. That means criminal laws common, most of the civil laws common, but there is a subset of these civil laws called the personal laws related to marriages, divorce, inheritance and adoption. This is where there is a discrimination. This is where members of different religious communities are governed under different sets of laws. When Constitution was enacted in the year 1950, Constitution talked about a directive. That means a directive principle was introduced into the Constitution under Article 44 of the Constitution of India. And Article 44 talked about that there shall be a uniform civil code. That means so far as matters related to marriage, divorce, inheritance, adoption are concerned, all religious communities should be governed under one common uniform law. That means why do we need different sets of laws governing these aspects differently for different religious communities? We should have one common uniform law for all the religious communities which will govern the matters related to marriage, divorce, inheritance and adoption. But this was only a directive principle of state policy. From 1950 till date, this uniform civil code has not been implemented in this country. Is it time for India to enact a uniform civil code? Let's have a discussion on that. We know that country witnessed partition in the year 1947 when the country was divided into India and Pakistan, and primarily on the grounds of the religion. So what the policy makers decided when the Constitution was enacted, then policy makers decided first, let's codify all the Hindu laws. And Hindus include Buddhists, Jains, Sikhs as well. Let's codify all these Hindu laws so that the discrimination that exists within this Hindu law is removed, so that we are codifying all these Hindu laws together. Let's allow intercaste marriages, which was not allowed till the enactment of these Hindu code bills, which we will discuss. Let's give property rights or inheritance rights to the women, because women were deprived of their right to inherit ancestral property. Let's provide her that right. Let's have the right for a Hindu woman to divorce her husband, which was not the right provided by the Hindu personal law. That means what Pandit Nehru and B.R. Ambedkar tried to do, they tried to codify all these Hindu laws so that there is one common uniform Hindu law applicable to all sections of the Hindus. That means in matters related to marriage, divorce, inheritance, adoption, all the members of the Hindu society will come under one common law. There shall be no discrimination on the grounds of caste. There shall be no discrimination on the ground of gender. That means immediately after the enactment of the Constitution, efforts were started to codify all these Hindu laws. But so far as Muslim laws, Parsi laws, Christian laws are concerned, they were left untouched, because we just witnessed a bloody partition on the grounds of the religion. So let's make it optional for them. Time will come, and time will come surely, when all these religious communities also will come under one common law. But for the time being, we will touch upon the aspects of the Hindu laws, we will codify them and check if there is any discrimination on the ground of caste, if there is any discrimination on the grounds of gender. Let's remove those discriminations, and then we can focus on the Muslim, Christian, Parsi laws. And ultimately, all the personal laws related to the Hindu community were codified by the parliament. But then there are critics who say if personal laws related to the Hindus can be codified, what about the Muslim, Christian and the Parsi law? Why can't we have a uniform civil code in this country? Is it time for India to implement a uniform civil code? Let's have an argument in favor of a uniform civil code, arguments against uniform civil code. Then we will talk about the Goa example of uniform civil code, because there is a uniform civil code under operation in the state of Goa. Then we will look at the Special Marriage Act of the year 1954. And then we will have an elaborate discussion on all these contentious topics. Let's look at the argument in favor of a uniform civil code. If Constitution talked about under Article 44 that there should be a uniform civil code, why is it that despite more than 7 decades of our Constitution, we are still not in a position to implement Uniform Civil Code. So we should respect the Constitution. If it talks about Uniform Civil Code, we should implement it. That is one argument. Second argument is, let's take the example of Muslim personal law. In Muslim personal law, divorce rights are not available for women. Women in Islam do not have the right to grant divorce to their husbands. If this right is available to a Hindu woman, to a Sikh woman, to a Jain or a Buddhist woman, why is this right not available to a Muslim woman? Is it not violative of Article 14 of Indian Constitution, which talks about right to equality? Is it not that fundamental rights should trump over all personal laws? If females of the other religious communities, they have the right that they can grant divorce to their husbands, why are Muslim women deprived of it? That is why we should have a uniform civil code. Then there is a third argument. If a Muslim man grants a divorce to his Muslim wife, he has to provide compensation. But this compensation is provided only for 3 months. That is what we call waiting period or iddat period. This compensation is not provided for her entire life. But what if this Muslim woman is not in a position to earn her livelihood? What if this Muslim woman is not in a position to feed and sustain her family? How can she survive in this cruel world? If a Hindu woman, when she is divorced by her husband, if she is provided compensation for her entire life, why is it that a Muslim woman who has been divorced by her husband is provided compensation for only 3 months? It is for this reason also that we should have a uniform civil code. Let's say, for example, adoption. Muslim personal law does not recognize adoption. Although there is a judgment of the Supreme Court, Shabnam Hashmi case. In this case, the Supreme Court has clearly ruled that even Muslim members can adopt children. But Muslim personal law does not recognize adoption. And it is for this reason that we should have a uniform civil code, because then all these disparities, all these discriminations will be nullified and all the religious communities will be governed under one common uniform law. Because in a secular state such as India, why should different religious communities be governed by different set of personal laws? That is unacceptable in a secular polity and in a democratic polity such as India. That is why, for these reasons, we should have a uniform civil code in this country. But then there are others who say that uniform civil code is not desirable. Uniform civil code is something which is not worth implementing. There are others who even go on to say that uniform civil code can never be implemented in this country. What are the arguments against uniform civil code? Let's say, for example, some constitutional experts say that Constitution only talks about uniform civil code. Constitution does not talk about common civil code. What is the difference between uniform civil code and a common civil code? They say that Constituent Assembly has very carefully used the term uniform civil code and not common civil code. If it was a common civil code, then we will have a common law related to marriage, divorce, inheritance, adoption for all the religious communities. But Constituent Assembly did not talk about common civil code. Constituent Assembly talked about uniform civil code. And what is this uniform civil code? One law for Muslims, one law for Hindus, one law for Parsis, one law for Christians. But if this law is available for Muslims, then for Muslims it should be uniformly implemented. That means within the Muslim community there should be no discrimination on the grounds of gender. If this is a common law for Hindus, this law should be uniformly applicable to Hindus regardless of the caste, regardless of the gender. That means intercaste marriages should be allowed. That means even the women should be provided right to inherit property. That means Constitution does not talk about common civil code, which means one law for all the religious communities. Constitution only talks about uniform civil code. That means if there is a law specifically for Muslims, it should be uniformly applicable to the Muslims regardless of any discrimination on the grounds of gender. If this is a law which is applicable to Hindus, it should be uniformly applicable to all sections of the Hindu society, regardless of any discrimination on the grounds of caste, on the grounds of gender. That is what Constitution envisaged in 1950. It talked about uniform civil code. It did not talk about common civil code. Argument number 2, they say if uniform civil code is implemented, it will be violative of Article 25 of Indian Constitution. It will be violative of Article 26 of Indian Constitution. Article 25 talks about every single individual in this country has a fundamental right to profess, practice and propagate religion. Now, if you are practicing your religion, for example, your religion tells you that polygamy is allowed. One reason why critics argue that uniform civil code should be implemented, they say that why is it that Muslim men are allowed multiple wives, but Hindu men are not, or Christian men are not? Why is it that polygamy for Muslims is acceptable and polygamy for other religious communities is not acceptable? Polygamy, it is understood that it is discriminatory against women. If a Muslim man can have multiple wives, he will not be in a position to treat all these multiple wives equally. So you are violating their right to equality as well. That is why polygamy should have no place in India. And that is why we should have a uniform civil code. Let's say, for example, there are some Orthodox Christians. They take the vow quite literally, the vow of till death do us part. That means there is no concept of divorce in some Christian societies. If there is no divorce, that means marriage is treated as a sacred institution, not only sacred institution, but indivisible institution. That means despite the fact that this marriage can be abusive, the relationship can be exploitative, the Christian women does not have the right to come out of that marriage. It is for this reason that we should have a uniform civil code. But then critics argue, who are opposed to uniform civil code, they say if Article 25 talks about right to religion, right to practice religion, and if my religion recognizes polygamy, how can a uniform civil code, which is a directive principle, how can this directive principle trump a fundamental right under Article 25? Because as of now, what we have understood, only 2 directive principles have superiority over 2 fundamental rights. 39B, 39C is superior than Article 14 and 19. But Article 44, which is a directive principle, is not superior than Article 25. So if we have to implement uniform civil code in this country, and if it takes away polygamy, which may be integral to Islam under Article 25, then how can you implement uniform civil code when right to religion is a fundamental right? Similarly, Article 26 of Indian Constitution, it talks about right of a religious denomination to establish, manage and administer religious institutions. This is something that can be taken away by uniform civil code. But how can Article 44 violate Article 26? That is why uniform civil code can never be implemented in this country. That means on one side of the argument, we have the advocates of a uniform civil code in the interest of gender parity, in the interest of anti-casteism. There should be uniform civil code in this country. For secular democracy, there should be uniform civil code in this country. As a respect to the Constitution, which talks about uniform civil code, there should be uniform civil code in this country. But there are critics who are the advocates that there should be no uniform civil code in this country. They say that Constitution only talks about uniform civil code. It does not talk about common civil code, number one. Number two, Article 25, 26 will be violated if uniform civil code is implemented in this country. But since directive principles are inferior than fundamental rights, we cannot implement uniform civil code. Then a big argument, Article 29 of Indian Constitution. Article 29 talks about every section of the society, if it has a distinct language, script or culture of its own, they have the fundamental right to preserve that culture. What about the culture of Northeast? What about the culture of Nagas? What about the culture of the various tribes in the Northeast? Some of these tribes, they practice polygamy. So how can you deprive these tribes of their practice of polygamy when they have a fundamental right to preserve their culture? Similarly, There are some tribes in Northeast where the divorce is granted by the way of splitting a leaf in the middle. So in the mainland India, you have to file a petition for divorce. In some tribes in Northeast, the divorce between the husband and the wife is carried out when husband takes a leaf and splits this leaf in the middle. That's how divorce is granted. If this is their culture, how they grant divorce, and the preservation of this culture is their fundamental right under Article 29, how can a directive principle violate this fundamental right? Similarly, there are some tribes where if the father-in-law passes away, the man marries his mother-in-law and supports the mother-in-law for her entire life. This will be considered immoral in mainland India, but that is part of their culture, and they have the fundamental right to preserve their culture. There are some tribes where a woman before her marriage, she marries her grandfather, and that is part of their culture. That means there are different customs in Naga society, different customs in different tribal societies. They have the fundamental right to preserve their culture. And if this is the fundamental right under Article 29, how can a directive principle under Article 44 violate these fundamental rights? That is why fundamental rights will have more primacy than directive principles of state policy. And that is why Uniform Civil Code can never be implemented in this country. There are those who say that the existence of different set of personal laws for different sections of religious communities, that is one glorious example of India's unity in diversity. We are a diverse country. We have a diversity in terms of language, script, culture, religion, language, cuisine, the way in which we dress. And this unity in diversity is recognized by our constitution. The presence of right to religion as a fundamental right, the presence of right to preserve your culture as a fundamental right is a testimony of the fact that our constitution believes in unity in diversity. If we are implementing Uniform Civil Code in this country, then we are changing our constitution from unity in diversity to unity in uniformity. And uniformity is something which is not desirable in a diverse country such as India. So this was the argument in favor of a Uniform Civil Code. This was the argument against Uniform Civil Code. And the critics also talk about the triple talaq judgment pronounced by the Supreme Court. They say, in this case, the majority opinion was that personal laws are similar to fundamental rights. That means the triple talaq judgment, where the 5 judges of the Supreme Court, a constitution bench of the Supreme Court declared that triple talaq is invalid. Instant triple talaq is something that cannot be allowed in our country. But even then, the majority opinion of the judiciary was that personal laws are similar to fundamental rights. That means personal laws have been elevated to the same status as fundamental rights. The then Chief Justice of India, Justice Kehar, Justice Nazir, Justice Kurian Joseph, by a majority opinion in this triple talaq judgment, they held that personal laws and fundamental rights, they can be equated with each other. If personal laws are same as that of fundamental rights, how can a directive principle violate these fundamental rights? That is why the critics to Uniform Civil Code argue that because of this triple talaq judgment given by the Supreme Court, it becomes very difficult to implement Uniform Civil Code in this country. That is why Law Commission in its report also has mentioned that instead of having Uniform Civil Code, what we should try and achieve, we should try and achieve uniformity within a personal law. That means within Muslim personal law, there should be no discrimination on the ground of gender. Within Christian personal law, within Parsi personal law, there should be no discrimination on the ground of gender. That is why even the Law Commission of India in its report has mentioned that we should not talk about Uniform Civil Code as of now, but what we should talk about, we should ensure that within these personal laws, there should be no discrimination. That means these personal laws should be uniformly applicable to the members of that particular community. That is what we should ensure. Law Commission in its report is against the implementation of Uniform Civil Code, but wants that within a personal law, this law should be uniformly applicable to all members of that religious community. But whenever there is a talk of uniform civil code, the example is cited of Goa. Goa is the only state in India which has its own uniform civil code, and that has got something to do with the Portuguese influence. Goa was a Portuguese colony when there was an agreement between Portuguese government and the government of India, because of which Goa became part of India. But even then, one of the conditions of the merger of Goa with the Union of India was that this Portuguese civil law should continue to be applicable to the Goans. That means all the people in Goa should not come under Muslim personal law or Christian personal law or Hindu personal law, but they should come under the Portuguese civil law. That means this Portuguese civil law should be uniformly applicable to all religious communities altogether. That means, to make it simple, in Goa, whether you are Muslim, Christian, Hindu, you will not come under Muslim personal law or a Christian personal law or Hindu laws, but you will come under this Portuguese civil law. And this is what the people in Goa bargained for at the time when they merged with the Union of India. But now let's critically analyze this Goan model of a uniform civil code, and we will raise a very important question, which tomorrow can be a question for your mains examination, that uniformity does not always mean justice. Even in uniformity, there can be discrimination. That is what I have written here. It can also mean uniformity in discrimination, in that you can have discriminatory provisions applicable across all religions uniformly. How? Let me try and explain to you in very simple words. In Goa, regardless of your religion, you will have to register for your marriage. And for that, 2 signatures are required. Let's say, for example, I have to marry. I will first give my intention that I have to marry before the registrar of marriages, and I will have to sign. This shows that I have the intention to marry. The second signature is at the time of the religious ceremony. And this second signature is to be carried out at the court. That means to legally register your marriage, 2 signatures are required. First, when I make my intention clear that I want to marry. Second, at the time of the marriage, in a court, I have to give my another signature. When both these signatures are there, the marriage is legalized, regardless of your religion. But for Catholics, for Christians, it is slightly different. They first sign the first signature, that means they make their intention clear that we want to marry. But the second signature is not required if the marriage is solemnized at the church. That means it is as if the state has entered into an agreement with the church. That means all the marriages that are solemnized at church, we are assuming that the second signature is taken. That means although there is uniform application of the Portuguese law for all the religious communities in Goa, but for the Catholics there is a special discrimination. They don't have to give their second signature if they solemnize their marriage at the church, because the church and the state seems to have an agreement with each other. The marriage solemnized at church will be treated as second signature, while this is not the case for a member of any other religious community. Now this is marriage. What about divorce? Husband and the wife, they can divorce each other. Husband has the right to divorce, wife has the right to divorce, and this is applicable to all religious communities, including Muslims. But for Christians specifically, the marriages that are solemnized at church, the church can annul the marriage, the church can grant the divorce in one case if the marriage is not consumed. That means if there is a Christian couple who got married at the church, if the marriage has not been consumed, that means there has been no sexual intercourse between the husband and the wife. If the marriage has not been consumed, this non-consummation of a marriage is a ground for divorce, because church can annul this marriage if the marriage has not been consumed. But this is not the case with other religious communities. For other religious communities, non-consummation of marriage is not a ground for divorce. What about inheritance? There is a beautiful concept in Goa Civil Code, and that is the regime of communion of assets. What is that? Let's say, for example, this is a man. He inherited some property. Let's say this property is X. There is a woman, she inherited some property. Let's say this property is Y. When husband and the wife, they marry each other, when the boy and the girl, they marry each other, all the assets that they have will be communally owned by both of them. That means the property inherited by wife, property inherited by the man, together will constitute communion of assets, and both will be the joint property holders of this asset. But it can also be that at the time of the marriage, the couple will decide, no, my property that I have inherited will remain with me. The property that you have inherited will remain with you. We will not combine the property together. That can also happen. But in case, if the ancestral property inherited by the wife, the ancestral property inherited by the husband, they are pooled together in communion of assets, the button of operation is given to the husband. What is happening in Goa right now? There are critics who say that in Goa, the husbands, they operate this communion of assets in such a manner that if this is a flat, for example, this flat is rent out on rent. This flat is rented and the rent is paid to the husband. Husband does not share this rent with the wife. On top of that, if this is the communion of asset, that means the property is jointly held. That means the property is jointly held by both husband and the wife. On this communion of asset, the husband is raising loans. The husband is approaching a bank and raising loans. And there are problems in Goa society right now where the wives are complaining that loans have been raised on our joint property, and the money that has been raised on account of this loan, this money is misused by the husbands when they misspend this money at the casinos. And sometimes wives are complaining that we don't know for what purpose our husbands have taken loans on this joint property. That means despite the fact that there is uniform civil code in Goa, despite the fact that regardless of your religious denomination, you will come under one common law when it comes to matters related to marriage, divorce, inheritance. But uniformity does not always mean justice. It can also be that we are discriminating women even here in Goa Civil Code. So tomorrow, if there is a question on the Goa model of Uniform Civil Code, you can cite these criticisms of the Uniform Civil Code that is currently implemented in Goa. This can also be an argument against Uniform Civil Code, because Uniform Civil Code as is implemented in Goa is not a model to be emulated, is not a model to be replicated in the rest of this country. That is what you need to know from the Goa model of Uniform Civil Code. But now let's look at another important and the last topic under Directive Principles of State Policy, and that is Special Marriage Act. Let's say, for example, there is a Hindu boy who is going to marry a Muslim girl. If Hindu boy does not want to convert to Islam, or the Muslim girl does not want to convert to Hinduism, is there a place in India for such a couple? Yes. And for that we have a law called Special Marriage Act, which was passed in the year 1954, which got implemented from 1st January 1955. The Special Marriage Act, it was meant to facilitate inter-religious marriages in India. But in practice, it actually creates huge hurdles. It is this Special Marriage Act which has turned India into a Khap Panchayat. What is a Khap Panchayat? In states such as Haryana, if there is an inter-caste marriage, or if there is a marriage within a Gotra in Haryana, then a group of elders in a village decide whether this boy should be killed or not, whether this girl should be killed or not, whether the boy or the girl should be exiled from the district or the village or not. That is what we call honor killing. Now let's look at the last topic under Part 4 of the Indian Constitution, Special Marriage Act. Let's say, for example, we have a Hindu boy who wants to marry a Muslim girl. But this Hindu boy does not want to convert to Islam. This Muslim girl does not want to convert to Hinduism. Is there a place for such a couple in India's society? Yes. And that is possible because of Special Marriage Act of 1954, which got implemented in this country from 1st of January 1955. The Special Marriage Act was meant to facilitate inter-religious marriages in this country. But when we look at the practice, it is creating more hurdles. This Special Marriage Act has made India a Khap Panchayat. What is Khap Panchayat? Let's say, for example, there is a state called Haryana. There, if there is an inter-caste marriage or an inter-religious marriage, or if somebody is marrying within a gotra, then there is a group of elders in a village. They decide what should be done to this couple. Whether the girl should be killed, whether the boy should be killed, or whether they should be exiled from the village. That is what we call Khap Panchayat, an extra-constitutional, illegal authority taking law into their own hands and deciding whether this couple who has fought the patriarchy, who has fought the religious bigotry, whether this religious couple should be killed or not. Khap Panchayat. And Special Marriage Act, unfortunately, which was enacted to facilitate inter-religious marriages, it has turned India into a Khap Panchayat. How? Let's look at the provisions of Special Marriages Act. In India, legally, there is a route to inter-religious marriages. That means if a Muslim wants to marry a Hindu without the need for either of the two to convert into each other's religion, he can stay Hindu, she can stay Muslim. If they want to marry, they can marry under Special Marriage Act of 1954. But now, to understand this in great detail, let me give you the background about how and when was this Special Marriage Act enacted by Indian Parliament. If you look at Revolt of 1857, what was the basic and immediate reason for the Revolt of 1857, for the mutiny of 1857? Enfield rifles. That means religion was endangered by the British Empire. That is why people were up in arms against the British Empire and they wanted to overthrow the British Empire. In fact, we can say that the principal reason for the revolt of 1857 was that the policies of the British Raj or the policies of the East India Company was against the religion in India. The people at that point in time knew that East India Company is trying to convert people into Christianity. Even when the rebels, they proclaimed Hindustan, the declaration of the revolt of 1857 clearly mentioned that now it has reached a point where the East India Company wants to convert everyone into Christianity. And this revolt of 1857 nearly swept away the British rule. Then the British realized that if we have to continue to rule over India for centuries and decades together, one thing we should not do, we should not touch their religion. That means leave their religious matters to themselves. We will not interfere in their religion. That is why prior to revolt of 1857, we saw the British policies were very gender friendly. British policies were in favor of reforming our religions. For example, sati was abolished. Widows were allowed to remarry. That is how Raja Ram Mohan Roy, Ishwar Chandra Vidyasagar played pivotal role in the abolition of sati and widow remarriages respectively. But then they soon realized that one thing we should not do, we should not touch their religion. And during the British Raj, was there an option where an inter-religious couple can marry each other? Yes. That was Act 3 of 1872. But this Act 3 of 1872 said, if there is a Hindu going to marry a Muslim, you can marry under this Act, then you will not come under Hindu laws, you will not come under Muslim laws. But first what you have to do, you have to give up your religion. You have to renounce your religion. When you renounce your religion, you can marry under Act 3 of 1872 because we cannot interfere in your religions. Because it was the Raj's policy, British Raj's policy of not interfering in the personal and religious lives of Indians. And this act also gave the right to a Hindu woman to divorce. Then when Constitution was enacted, then the steps were taken by B.R. Ambedkar and Pandit Nehru that we should reform the personal laws related to Hindus. There was huge controversy surrounding the same. Even the Congress members were against Pandit Nehru that you should not touch our religion. Significantly, when 3 Hindu code bills were introduced in the parliament, the opposition to these Hindu code bills were so huge that B.R. Ambedkar ultimately had to resign. These Hindu code bills gave the right to a Hindu woman to divorce. But the Orthodox Hindus at that point in time said, if you are giving women the right to divorce, our whole society will collapse. Our whole society will disintegrate. Because marriage is sacred. Marriage should not be dissolved. They were also against giving women the right to ancestral property. They were also against intercaste marriages. So when these Hindu code bills were debated in the parliament, B.R. Ambedkar had resigned. But Pandit Nehru still tried to persuade the Congress members that we should go ahead with Hindu code bills, we should codify the personal laws related to Hindus. But at the same time, Special Marriage Act was also being discussed in the parliament. And the members of the Congress party, they told Pandit Nehru that we will support your Hindu code bills. But for that, what you have to do, you have to water down this Special Marriage Act. And that is how some provisions were inserted in the Special Marriages Act by Pandit Nehru, because he wanted to please the Congress members so that these Congress members can get the Hindu code bills passed. That is why some clauses were added to the Special Marriage Act, which weakened this act altogether and has converted India into a Khap Panchayat. This is the background. This is how Special Marriage Act was passed by the Indian Parliament. Now let's look at what are these provisions of the Special Marriage Act. These provisions are nothing but concessions that were given to the conservatives in 1954 so that these conservatives can back the passage of Hindu code bills. And because of which some clauses were added to Special Marriage Act which weakened this act and turned India into a Khap Panchayat. How? Let's say number one, I want to marry, but my marriage is intercaste marriage or interreligious marriage. For that, what I have to do? I have to approach the civil court. I have to approach the marriage officer. And marriage officer will notify on the board that there is this man and this woman, they want to marry. And after 1 month, they will get married. That means this notice period will be issued. The validity of this notice period is 1 month. That means after 1 month, the marriage will take place. The marriage will be solemnized at the civil court. What is this 1 month period for? If anybody has any objections against this marriage, please come to the location. That means basically you are inviting force. You are inviting members of my community, members of her community. Let's go together to the civil court and prevent the marriage from taking place. So Special Marriage Act, which was a beautiful act to legalize intercaste marriages, interreligious marriages, without the need for one of the two to convert into each other's religion. Now what has happened? There is a notice period of 1 month. This 1 month notice period is like an invitation to caste leaders, religious leaders, that please come to this location, disrupt the marriage so that the marriage does not take place. In such a situation, it becomes very difficult for the couple to go for a marriage. And what is the only solution? Conversion. A very famous journalist, woman journalist, she's also a daughter of a prominent politician. I won't name him or her because that is immaterial. But what she says is of profound significance. She says that it is easier in this country to marry under a personal law rather than marrying under a Special Marriages Act, because there are so many lacunas and loopholes, so many conditions in this Special Marriage Act, that if I have to marry a Muslim, for example, it is better for me to convert into his religion or her religion and then I will marry. That's number one. Number two, let's say for example, I'm from Delhi and I have to marry a girl from Bangalore. Now the marriage is to take place. Her family is against the marriage. My family is also against the marriage. So we can't solemnize the marriage either in a Delhi court or in a Bangalore court. So what is the only option available to us? We will run away. We will run away from Delhi or Bangalore. We'll go to Jharkhand. We'll go to Tamil Nadu. We want to solemnize our marriage there. But the Act, Special Marriage Act, stipulates that an application for marriage can be made only in a place where at least one of the parties resides. That means we have to submit an application either in Delhi or in Bangalore. That means runaway marriages are now not possible under Special Marriages Act. That's another problem. Now let's look at another provision. Let's say for example, I'm from Delhi and my would-be wife is from Bangalore. I'm taking her to Delhi, and in Delhi we are registering, filing an application for marriage, but then the marriage officer sees that the girl is from Bangalore. So if one of the party is not from Delhi, then what this marriage officer will do? It will send a notice to a Bangalore court, informing the Bangalore court that there is a lady from your jurisdiction who has come to Delhi for marriage. Please put up a notice. If anybody has any objection with this marriage, you can file objections with our court. So what is it? It's like an open invitation. All these caste leaders or religious leaders in Bangalore, book your train tickets, book your air tickets, come to Delhi, disrupt our marriage. Because this is Special Marriage Act. In effect, what this means, that there is a marriage officer in Delhi who sends a letter to Bangalore that what your daughter is doing, she has decided to do something unthinkable. And what is this unthinkable? Exercise her fundamental right to marry someone of his or her choosing. What is the effect? Please look at this paragraph carefully. In practice, therefore, by making sure that parents as well as caste or community leaders are aware of the time and location of the intended marriage well in advance, the Indian state acts like a super car panchayat by making sure that society decides whether the couple should get married or not. That is another problem with Special Marriage Act. But I told you that the Special Marriage Act was watered down because Pandit Nehru wanted to give concessions to the conservatives in the Congress party that you please support our Hindu code bills and we will water down Special Marriage Act. And the Special Marriage Act was watered down. How? If I'm a Hindu, and Hindu includes Buddhists, Jains, Sikhs as well, if I decide to marry a non-Hindu, then I cannot claim a right to my ancestral property. That means I will forfeit my right to my ancestral property. That means what basically you're doing, you're prohibiting a Hindu from marrying a person of a different religion. Interestingly, this applies only to Hindus. It does not apply to Muslims, it does not apply to Christians. That means it seems that while the Indian Republic hates the idea of interreligious marriages, one involving a Hindu gives it special heartburn. That is what you have to understand regarding Special Marriage Act. And why we are discussing Special Marriage Act? Because there are people who say that even if Uniform Civil Code is not implemented, we have a secular law in the form of Special Marriage Act. Let every single individual in this country register for marriage under Special Marriage Act, then we don't need these personal laws. But the problem is that even this Special Marriage Act, unless and until it is reformed, unless and until these issues are resolved, we cannot say that Special Marriage Act is a solution to Uniform Civil Code in this country. So what have we discussed in this chapter? We talked about directive principles of state policy. We talked about the objective of directive principle of state policy is to create or establish a welfare society, is to establish social and economic democracy in this country. What is the relationship between directive principles and fundamental rights? We discussed. We discussed why directive principles are not enforceable in a court of law. We discussed that yes, almost all of these directive principles have been implemented, but there is one contentious directive principle which is still not implemented, and that is Uniform Civil Code. We talked about arguments in favor of Uniform Civil Code. We talked about arguments against Uniform Civil Code. We talked about the often cited argument that Goa Uniform Civil Code is a solution to India. Goa Civil Code is a model that should be replicated in the rest of this country. And we have examined that although uniformity is there in Uniform Civil Code of Goa, but uniformity does not always mean justice. Uniformity can also mean that we are discriminating uniformly. And then we talked about when people say that Uniform Civil Code can wait, Uniform Civil Code is not required, what we should do, we should ensure that there is much publicity of Special Marriage Act. More and more people, almost everybody, should register for their marriages under Special Marriage Act. And if you register your marriage under Special Marriage Act, then whether you are Muslim, Christian, Sikh, Parsi, you won't come under your personal laws, you will come under the secular law called Special Marriage Act. But even there, we see some problems in Special Marriage Act, which has in effect converted India into a Kha Panchayat. That is it that you need to know regarding directive principles of state policy.